welcome back to another episode of Courts this week, presented by Livelaw. I'm your host, Ostika Das, and I'll take you through the most significant courtroom developments from across the nation. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website, www.livelaw.in. In this episode, we are going to talk about Hemant Soren's arrest, the Gyanvapi Mosque dispute, the Parliament security breach case, and much more. So let's dive into the headlines. We begin with a development related to the arrest of former Jharkhand Chief Minister Hemant Soren on Wednesday by Enforcement Directorate on money laundering charges in an alleged land scam case. Apprehending his arrest after being questioned for over 7 hours by officials from the central agency, Soren resigned as Chief Minister this week. He challenged this arrest both in the Jharkhand High Court and the Supreme Court. After Soren's request was mentioned for an urgent hearing, Chief Justice D.Y. Chandrachud constituted a special bench of Justices Sanjeev Khanna, M.M. Sundaresh and Bela M. Trivedi to hear the writ petition under Article 32. However, despite his legal team comprising senior advocates Kapil Sibal and Abhishek Manu Singhvi questioning the necessity of the arrest and alleging that this formed part of a vindictive plan to topple the state government ahead of the general elections, the bench declined to entertain Soren's petition. It asked the Jharkhand Mukti Morcha chairperson to instead pursue a legal remedy before the High Court under Article 226, clarifying that he was at liberty to seek an expeditious listing and disposal of his petition there. The judges also declined a request by Soren's lawyers to fix a time frame for the High Court to hear the matter, with Justice Khanna categorically saying, "When you press for it, they will hear you out. We are not going to control the High Court." Chief Justice D.Y. Chandrachud has agreed to consider an urgent listing request for AAP councillor Kuldeep Kumar's petition challenging the Chandigarh mayoral election result. Kumar has moved the Supreme Court after the Punjab and Haryana High Court declined an immediate stay on the results, adjourning the hearing until after 3 weeks. Kumar has alleged vote tampering in the Chandigarh mayoral elections won by BJP candidate Manoj Somkar on 31st January. Before the High Court, Kumar sought the setting aside of the election result, claiming that it resulted from fraud and forgery. He prayed for fresh elections under the supervision of a retired High Court judge. The BJP candidate secured 16 votes against Kumar's 12, backed by Congress and AAP, with 8 votes rejected as invalid. While issuing notice on the plea, a division bench of Justices Sudhir Singh and Harsh Bangar granted 3 weeks' time to the respondents. However, it declined the AAP councillor's request to dissolve the functioning of the office until further orders. Whether counting was proper, whether procedure was followed or not, these are all questions of fact, the bench reasoned. Kumar has now approached the top court against the High Court's refusal to grant an immediate stay. We will be back with more updates in this case. A Supreme Court bench of Justices Sanjeev Khanna and Dipankar Datta has declined to entertain Andhra Pradesh's government's petition against anticipatory bail granted to former Chief Minister and Telugu Desam Party President N. Chandrababu Naidu in the Inner Ring Road alignment scam case. The case revolves around allegations of corrupt practices related to the formulation of the master plan for Amravati, the state's capital, and the alignment of the IRR supposedly favouring entities linked to Naidu. The charges span the years 2014 to 2019 during Naidu's tenure as Chief Minister. Notably, Naidu is already facing charges in 3 other alleged scams: the FiberNet scam, the skill development scam, and the liquor scam. During this week's brief hearing, Naidu's counsel, Senior Advocate Siddharth Luthra, pointed out that the state government's plea against anticipatory bail for co-accused persons had already been dismissed by the Supreme Court in previous cases. Justice Khanna reasoned that since the allegations, FIR and facts were the same, the court could not entertain the petition at this juncture. In a recent development concerning the Calcutta High Court, the Supreme Court addressed the ongoing discord between a single bench and a division bench. Last week, on 25th January, a division bench of the Calcutta High Court stayed a decision by Justice Abhijit Gangopadhyay, who had ordered the immediate transfer of a state-led investigation into the admission of reserved category candidates to medical colleges to the Central Bureau of Investigation. Despite the division bench's stay, Justice Gangopadhyay labelled the order illegal and void ab initio on the same day, asserting that Justice Soren of the division bench had a vested interest in the matter. Taking suo motu cognizance on 26 January, the Supreme Court held a special Saturday hearing, staying the proceedings in the writ petition before the single bench and the letters patent appeal before the division bench. During a subsequent hearing, a 5-judge Supreme Court bench presided over by Chief Justice D.Y. Chandrachud and comprising Justices Sanjeev Khanna, B.R. Gawai, Suryakant and Aniruddha Bose decided to transfer the matter to the Supreme Court itself. The case will be listed after 3 weeks. The Supreme Court expressed astonishment this week over a practice observed in Gujarat courts where police are granted the liberty to seek remand of an accused even after the court grants anticipatory bail. A bench of Justices B.R. Gawai and Sandeep Mehta was hearing a contempt petition against police officials and a judicial magistrate in Gujarat. The contempt petition arose when an accused was remanded to custody despite the Supreme Court's interim anticipatory bail order. During the hearing, Solicitor General Tushar Mehta informed the court that departmental action against the officer was underway. He explained that in Gujarat, it was a common practice for bail orders to include a condition allowing the investigating officer to apply for remand. Under this mistaken belief, the officer in this case applied for remand, which the magistrate subsequently allowed. The Supreme Court, expressing surprise, noted that such a practice undermines the purpose of granting anticipatory bail, thereby compromising personal liberty. The bench recommended proper training for judicial magistrates in the state and added the Gujarat High Court as a party to the proceedings, issuing notice to the High Court through the Registrar General. In a noteworthy decision, the Supreme Court has issued an order prohibiting the mention of caste or religion in the memo of parties and petitions or court proceedings. This directive came about during the hearing of a transfer petition involving a family dispute where the caste of the parties was noted in the memo. Expressing dissatisfaction, the court emphasized the need to shun and cease the practice of mentioning a litigant's caste or religion. When the petitioner's counsel explained that the registry might object if changes were made, the court clarified that the directive would apply irrespective of whether the caste or religion of the parties was previously provided in lower courts. This move follows a similar criticism in October last year by a bench led by Justice Abhay Oak, which condemned the practice of mentioning caste or religion in the cause title of judgments. This week, Justices Hima Kohli and Ahsanuddin Amanullah, while issuing this significant direction, also emphasized immediate compliance by submitting a copy of the order to the relevant registrar and circulating it to the Registrar Generals of all High Courts. Next, let's turn to news from other courts, specifically what's happening in the Gyanvapi Mosque dispute case. If you remember, last week a Varanasi court had ordered the Archaeological Survey of India to make its scientific survey report public. The court, while disposing of applications from concerned parties seeking access to the report, ruled that all relevant parties should be provided with the findings. The ASI survey aimed to determine if the mosque was built over a pre-existing Hindu temple structure. Last August, the Supreme Court had permitted the ASI to conduct this survey, excluding the Wuzukhana area where a Shivling was claimed to have been found. The ASI's report, now made public, reveals that a large Hindu temple existed before the construction of the Gyanvapi Mosque. Subsequent to this development, on 31st January, the Varanasi district judge directed arrangements for Hindu worship in a sealed cellar, a practice halted in 1993. This decision followed the administration taking possession of the cellar last week. However, the very next day, that is on 1st February, the Mosque Committee urgently sought status quo restoration, alleging haste in implementing the Varanasi court's order. However, the Supreme Court turned the Mosque Committee away, asking it to approach the Allahabad High Court instead. In the latest development, on 2nd February, the High Court declined interim relief to the Mosque Committee, emphasizing the absence of a challenge to the 17th January order appointing a receiver. Although no temporary stay was granted on puja inside the Vyas Tekhana, the court granted time until 6th February for the committee to amend its appeal, while instructing the Advocate General to maintain law and order in the area. This week, the Bombay High Court rejected actor Kangana Ranaut's plea to stay the criminal defamation case filed against her by lyricist Javed Akhtar in 2020 and also declined her request to merge it with her cross-complaint against Akhtar. Justice Prakash Naik in the order emphasized that Renaud had not previously asserted that the cases were cross cases, and even if they were, Akhtar's complaint was filed first. The defamation case revolves around Akhtar's allegation that Renaud damaged his reputation by dragging his name into actor Sushant Singh Rajput's death during an interview with Republic TV in 2020. Renaud, in her writ petition, argued for a joint trial, claiming both cases originated from a 2016 meeting. However, Akhtar contested her petition, labelling it an attempt to delay the defamation case. He highlighted that Renaud had already filed 9 legal challenges before various courts, all of which were dismissed, and subsequently filed a counter-complaint with false allegations after these rejections. In another significant development, the Bombay High Court delivered a split verdict on petitions challenging certain provisions of the IT Amendment Rules of 2023, which empower the central government to establish a fact-checking unit for identifying fake, false or misleading information about its business on social media platforms. Notably, social media intermediaries are required to take down such content or add a disclaimer upon the FCU's identification. Petitioners, including political satirist Kunal Kamra and media associations, argued that the rules could lead to arbitrary censorship and content removal. The Ministry of Information and Technology contended that fact-checking would ensure the dissemination of authentic information related to the government's business. In a split decision that was delivered this week, Justice Gautam Patel sided with the petitioners, while Justice Neela Gokhale upheld the amendment. This case will now be referred to a third judge as per Bombay High Court rules. Solicitor General Tushar Mehta assured the court that the FCU would not be notified for another 10 days. The court granted petitioners the liberty to seek further protection through an application before the appropriate forum. We come to the last update for this episode. The accused individuals in the UAPA case related to the Parliament security breach in December last year have claimed to be subjected to torture and coercion during their arrest. According to an application filed before Additional Sessions Judge Hardeep Kaur at the Patiala House Courts in Delhi, 5 out of 6 accused assert that they were forced to sign blank papers, given electric shocks, and compelled to confess to alleged crimes in connections with political parties. The submission further states that the accused were coerced into providing passwords for their social media accounts, emails and phones. Additionally, during polygraph or narco tests, 2 individuals were allegedly pressured to name a political party or leader. The accused were presented before the court and their judicial custody has been extended until 1st March. The court has scheduled the application for further hearing on 17 February and directed the Delhi police to file its response. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire livelaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audiovisual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host Ostika Das, and I will see you again next time.